legislature right now. And Tommy is going to cover many interesting bills with you. And Judge Phil King out of Weatherford will sponsor the bill for the House. And Representative Will Metcalf of Conroe has signed on as a joint author. The coalition we belong to, Asset, is recruiting additional joint authors for the bill in the House. Previously, as you know, last session, we tried to pass this bill and we had some opposition. Currently, those previous opponents are now neutral and plan to stay that way, which is great news for the potential of actually passing this important legislation. We have limited calendar days and have some big contentious bills in the pipeline. So it's critical that we get this bill to the full House as soon as possible. If you would like additional information on Senate Bill 14 and you don't have a local chapter or you're not connected legislatively, please feel free to reach out to me directly. You can reach out to Dina and she'll put you in touch with me and I can get you connected on the track with that bill and some suggestions. Well, this session has been fun. We've seen over 7,664 bills introduced. Some will pass, some will die. Many will be debated straight along party lines. Originally, we thought this session, because of the pandemic, might be held to pandemic-related items, passing a budget, funding education, and redistricting. Well, we found that not to be true. Who would have ever thought that we would be having energy regulation like we're facing in Texas based on our issues that we had during the freeze? It's like drinking from a fire hose around the legislature right now. And Tommy is going to cover many interesting bills with you in just a bit. But first, we are so excited to have SHRM's head of government affairs share a message of elevating the voice of HR and sharing 3 of SHRM's policy interests. Emily M. Dickens, JD, serves as SHRM's corporate secretary, chief of staff, and head of government affairs. She is the executive responsible for coordinating staff to implement the CEO, Johnny C. Taylor's vision for SHRM. She's the liaison for the SHRM board and subsidiary boards, an executive with oversight of external partnerships, public policy, government affairs, and administrative services. She's currently a member of the Strategic Education, Inc. Higher Advisory Board, the Board of National Foundation for Women Legislators, the Advisory Council of the Congressional Hispanic Caucus Institute, the Advisory Board of the College of Arts and Sciences at North Carolina Central University, and chairs the International HBCU Task Force for Alpha Kappa Alpha Sorority Incorporated. Emily is a graduate of North Carolina Central University and North Carolina Central University School of Law.
Good afternoon, everyone. I'm Kristen Bauer. I'm a principal in the Dallas office of Jackson Lewis. Along with Pam and Lisa Blanton, I serve as a Texas SHRM Government Advocacy co-chair. We're so pleased to have a Texas treasurer with us here today, Tommy Simmons. Tommy serves as legal counsel for the commissioner representing employers at the Texas Workforce Commission. Tommy advises the commissioner on final level appeals, assists business groups with employment-related legislation, counsels employers on Texas federal and employment laws, and frequently speaks to employer groups on employment law topics. I mean this in the most flattering way possible. Tommy is a human encyclopedia of employment law. He provides practical and valuable insights on everything from employment law basics to the most obscure provisions of the Texas Administrative Code. I speak from experience on this. Tommy has also authored a go-to resource for human resource professionals and employers called Especially for Texas Employers, which is available on the TWC website. Tommy is also the editor of the Texas Association of Business Employment Law Handbook and has created an app with employment law utilities for employers. Tommy, thank you for being here today to share your insights with the HR community. We look forward to your presentation.
Oh, thank you very much for that kind introduction, Kristen. I really appreciate it. And thank you to SHRM for inviting me to talk. I'm going to share my screen now. I've got a PowerPoint presentation that I would like to use to illustrate these bills here. Let's see here. All right. I'm going to try to get it started. Hopefully everybody can see now that we've got the legislative and TWC update for 2021. I'm also going to be providing a few updates about other areas as well. Recent federal legislation of import. My contact information is here on this first slide and also on the final slide of this presentation, including my direct office line down below. The book that Kristen referred to is online. It's a free book for employers, and it's the web address at the third line from the bottom. The web app is the web address at the second line from the bottom here. All right. Now, just before I get into the legislation, I'm going to cover, hopefully with lightning speed in the interest of time, a few important things. And most of this I'll just leave to y'all to read at your leisure when you get copies of the presentation. But on these first two slides are my top tips for employers. These are the tips that I would want to take with me if somebody told me, hey, Tommy, we're going to maroon you for years on a remote desert island, and you can only take a limited amount of stuff with you. These are the tips for employers that I would take, so that in case anybody found a way to contact me on that desert island, I could tell them these are the most important things to worry about if you're an employer. And a quick plug for what I consider probably the most important thing. It's not really the most important thing, but it causes the most trouble if you don't have it, and that's the W-4. So we recommend that before you let any new hire perform any work at all, that you get them to do the W-4. Because as those of y'all who have had employees ghost you after the first or second day of work, but they still need to be paid, and you still need to report the wages and pay the payroll taxes, how are you going to do it without the information on the W-4? So get the W-4 completed and signed by the employee before you let them do any work at all. Okay, so that's the second page of best practices, but I'm just going to fly through these. New hire paperwork. Other things are important as well. The I-9, W-4, notice of workers' comp coverage or non-coverage, but you got to get that W-4. I keep saying that, don't I? It's like a broken record. Now, TWC, my agency, is a state partner of several federal agencies, and we have a lot of important work to do to help enforce federal law on a state level. For instance, through our Texas payday law, Chapter 61 of the Texas Labor Code, we help the Department of Labor enforce the Fair Labor Standards Act. We do that through one of our rules for the Texas payday law, which says that in cases involving minimum wage and overtime pay, we will apply the standards and guidelines, including case law, from the Fair Labor Standards Act. So if you feel like you're really well grounded in federal wage and hour law, you'll be happy and at home with the Texas payday law on minimum wage and overtime claims. Fair Labor Standards Act, we see a lot of cases dealing with companionship and domestic employee regulations. The EEOC, we're the state partner for the EEOC here with our Civil Rights Division. We enforce the state equivalent of all of the EEOC laws. So, and that's in Chapter 21 of the Texas Labor Code. Nlrb, the Nlrb, of course, I'm sure y'all have noticed that they can be pretty active on a lot of employment law matters. And we have seen Nlrb rulings and cases show up in a lot of our unemployment claims. In OSHA, health and safety at the workplace, very, very important. And if somebody has an unemployment claim and there are some OSHA issues in there, if your company has been complying nicely with OSHA regulations, health and safety standards, and so on, you'll probably do okay with regard to those issues in the unemployment claim. So those can be very, very important. All right. Now, I want to quickly mention that there's been some recent movement on the case law with sexual orientation and transgender issues, the most important of which is the Supreme Court ruling down at the very bottom. That's the name of the case and how to find it in the books. And I'm sure you've seen plenty of articles about it, so I won't go into a lot of detail, but basically, all kinds of LGBTQIA plus issues are covered under the general category of sex discrimination, discrimination on the basis of sex. So that is, Supreme Court case law now. It's the law of the land. And so hopefully everybody's in good shape with that. Hopefully everybody's already heard that the Department of Labor set the salary threshold for exempt white collar employees, executive, administrative, professional, and computer professional employees at $684 per week, and highly compensated employee threshold, that's $107,432 per year. Up to 10% of the salary amount can be non-discretionary bonuses and other incentive payments such as commissions. Importantly, there's been no real change to the duties test. The duties tests are still very, very important, and they basically help sort out people who are legitimately salaried exempt employees from people who are, paid a salary, but they just don't cut the mustard as far as, meeting the duties test requirements for being a salaried exempt employee. A big issue all over the nation is this idea about predictive scheduling. This is especially important for a lot of, like fast food restaurants and similar places, but it theoretically applies to all kinds of employers in states and cities around the country where that's been adopted. This is a very important issue, predictive scheduling, basically being able to predict what the work schedule is in advance, and requirements that employers give employees usually at least 1 week, in many cases 2 weeks advance notice in writing of what their work schedule will be, and penalties for changing those schedules without proper notice to the employees. These are the various issues that come up on predictive scheduling. I won't go into detail on each one, but each one of these is usually covered in any ordinance or proposed legislation that you see regarding predictive scheduling. The status now, we actually had an ordinance on that in Austin in 2018, but it was put on hold by the Austin Appeals Court. It is possible that, state limitation of such ordinances might come about. Senate Bill 14, Senator Creighton's bill, that was actually placed on the Senate's intent calendar today. So it's probably going to come up for a vote very soon. That would basically prohibit local and county governments from enacting predictive scheduling requirements for employers. But in any event, this bill, HB 401 by Representative Hernandez, the most recent action on that was on March the 16th. It was left pending in the House committee. So we don't have any state law on this right now under current law. A question that comes up, what if employees show up or they have, part of their work shift canceled? Do they get paid for any part of that? Under current law, the answer is no, unless there's a wage agreement to the contrary, in which case you follow the wage agreement. As a general matter, work schedules are completely up to an employer's discretion. And in the book, that issue is covered in the topic that is shown as a link there. And as far as the Fair Labor Standards Act, the Department of Labor, their guidance on that is real hard to find, but they've got case law on that, and it's in the Field Operations Handbook. Basically, what it all sorts out to is courts agree that in the case of split shifts where employees work in the morning and not in the middle of the day and then they come back for an afternoon or evening shift, they don't have to be paid for the time between the split shift segments, as long as there is at least 1 hour in which they are fully relieved of duty between the portions of the split shift. Plus, the employer needs to show that the employee was aware of the free time and when the next portion of their workday would begin. This is a tricky topic, though, and you can tell that lots of elected officials would like to change that to tighten up the standards. Civil rights and discrimination, as far as state legislation, HB 21 filed this session would extend the deadline for filing a CRD, Civil Rights Division sexual harassment complaint from 180 days in the current law to 300 days. HB 38 and a couple of companion bills in the House and Senate would prohibit discrimination on the basis of hair texture or protective hairstyle associated with a person's race. So that's an interesting idea. These are just sorting their way through the committee process right now, though. HB 48 and the Senate companion SB 45, that would create an entirely new subchapter C-1 in Chapter 21, basically applying the definition of sexual harassment for unpaid interns to all employees. And it would also adopt a definition of employer similar to the one used in the Fair Labor Standards Act. So anyone who acts on behalf of an employer or in the interests of an employer, it would be there. And the interesting thing about this legislation is it would extend sexual harassment law down to all employers with even one employee, which is unprecedented because the civil rights legislation in Chapter 21 applies under current law to employers with 15 or more employees. Okay, then a whole lot of bills down this bottom bullet item. You see the ones listed there. Lots of legislation aimed at ending discrimination against people on the basis of sexual orientation or gender identity, and various classifications thereunder. So some of this is quite far-ranging, and a lot of it is based on that 2020 Supreme Court ruling in the Bostock case. So keep an eye on that. Those are going to be important because if they are enacted into law, that would amend Chapter 21 of the Texas Labor Code and bring that into state law, what is already practiced on the federal side. Okay. In the area of employee and family leave, this first bullet item, HB 87, HB 284, HB 1298, they would all require employers to provide paid leave to employees. The others would apply to even the tiniest of employers, but HB 284 would apply to employers with 50 or more employees, kind of like the FMLA. HB 247 would create a new Chapter 84 in the Labor Code that would create a state level FMLA requirement for Texas employers for up to 30 days of eligible leave there. HB 361, that would create a franchise tax credit for any taxable entity that provides family care leave. So it's kind of like a carrot approach, put a carrot at the end of a stick. HB 4100 goes further than HB 247. It would create a new Chapter 85 in the Labor Code. It would be a state level FMLA requirement, but with up to 12 weeks of leave eligibility, and it could be paid or unpaid with the option to apply available paid leave to the time. In the category of general human resources type legislation, non-leave benefits, we've already discussed Representative Hernandez's HB 401, the predictive scheduling bill. HB 757 would prohibit consideration of deferred adjudication outcomes in the criminal process, deferred adjudication, in employment, housing, and professional licensing decisions. That is very far reaching. And of course, that would change a lot of hiring practices that are currently in use. HB 779 would require school districts to reimburse classroom teachers if they buy school supplies out of personal funds, which, a lot of people think, isn't that the law already? But strangely enough, it's not the law. HB 1323, that would affect job training requirements for nursing care employees. It would just add an additional professional education requirement for anybody who is employed in a nursing care facility. HB 1327, very interesting. It would provide that a covenant not to compete is void and unenforceable if the promisor, the one who makes the agreement, is somebody who was fired without good cause. And here we have a definition of good cause. Now, this applies to covenants not to compete, but imagine a future in which somebody wants to do away with the, employment at will rule in Texas, where just like in California, you have to have good cause to discharge an employee. Well, here is a ready-made definition of good cause, and it's in this bill for covenant not to compete, but it's something that could be reused for other purposes in future years if legislation is filed to such an effect. Continuing with general human resources, HB 1330, that would actually bring into state law some Federal Trade Commission guidelines for consideration by employers of consumer credit reports of employees and applicants for jobs. HB 3529 and SB 571 would require employers to get a parent's or guardian's permission to obtain personally identifiable information, personal identifying information from a minor or from an individual who has a mental illness or intellectual disability. So that's probably one of those things that it's a good idea anyway, but this would make it into formal law. SB 14 and also SB 551, both of these would prohibit local governments from mandating leave or other benefits in excess of what is in Texas or federal law. SB 14 adds hiring practices, scheduling practices, and other terms of employment to that same prohibition. So that goes further than SB 551. SB 271, it would require written statements in addition to criminal background checks for applicants for employment at assisted living facilities. So that would be another layer to the hiring process for any employees who are going to work at assisted living facilities. And finally, for general HR law, SB 436 would impact health benefit plan coverage of pre-existing conditions. If somebody has COVID-19, that would be included in health benefit plan coverage of pre-existing conditions. Finally, SB 546, very interesting piece of legislation here, and it's gone relatively unnoticed under the radar. This would actually repeal section 52.062B of the Labor Code. And I invite, anybody who has an interest in, weapons at the workplace to look at that section of the Labor Code. Basically, that's the one that says that employees can have personal firearms that they are otherwise authorized to have in a personal vehicle if it's in a locked personal vehicle left in an employer provided parking space. And it also says that an employer is not prevented from adopting a policy prohibiting employees from bringing firearms into or inside the business premises. Well, if that is done away with by SB 546, there may be some misunderstandings by some employers. Some employers may panic and think, oh, we can't keep employees from bringing pistols into the store. Well, they can still do that, but it's under a more amorphous and general, doctrine of property law, whereby basically the custodian or the owner of property has a right to control who or what comes onto their property. So it would lead to some misunderstandings, and it could, be tense. Immigration e-verify. There's some e-verify legislation here. Basically, the ones at the top here would require state contractors and political subdivisions to use e-verify. And interestingly, these bills, if passed into law, they would require a local government or a state contractor to fire an employee who fails to follow the e-verify requirements if that's part of their job. And SB 766, kind of a niche requirement here, but it's one of several pieces of legislation dealing with sexually oriented businesses. And basically they would have to use e-verify, presumably to, verify who they are and what their age is because of the minimum age and so on. All right, getting into pay and wage and hour type bills, lots of minimum wage legislation. All the bills up at the top, those 8, all have to do with increasing minimum wage. Some of them start at 10.10, a couple at 11, one at 12, and many at 15. But some of them would go gradually. Some of them would increase it to $15 per hour right away. But all of them would do away with the current federal preemption under the Texas Minimum Wage Act in Section 62.151 of the law. The Minimum Wage Act does not apply if the Fair Labor Standards Act applies. That provision would be repealed if any of these go into effect. And most of these others that deal with minimum wage also include a repealer for Section 62.151. HB 190 and Senate Bill 1834, I kind of think of that as the wall of shame bill. Basically, these would require the TWC to maintain a database of employers who have been penalized for failure to pay wages, or they have been convicted of certain criminal offenses involving wage theft. And it would be a 3-year period. If you get on that list, you're on there for 3 years. And there's a way for getting off, but that would be a publicly available database of people who have violated wage payment laws. HB 250, $15 per hour for school bus drivers. HB 224, authorization for a county or municipality to establish a local minimum wage. HB 405 and SB 57, that would increase the deadline for filing a payday law wage claim from 180 days to a year after the wages became due for payment. HB 732, minimum wage for public school employees would be $15 per hour under that law. Another set of wage and hour laws, HB 1915. This is extremely interesting, and it is so granular. It's such a kind of a niche bill, the way it's addressing certain exceptions to overtime pay laws under the Fair Labor Standards Act. And these exceptions are found in Department of Labor regulations. So guaranteed weekly pay for variable hours would not be available anymore. Neither would fixed salaries for fluctuating work weeks. It would also require, under Texas law, for the very first time, we would have an overtime pay requirement. We don't under current law. We just follow the federal law, but this would say pay time and a half for hours worked in excess of 40 in a week. They don't say work week like the Department of Labor does, Fair Labor Standards Act. It just says week. And so I suppose that the TWC might be called upon to adopt a regulation defining week, and we'd probably use the FLSA definition, which is basically any 7 consecutive 24-hour period designated by the employer. HB 2614, a lot of ways to make it easier for the TWC to impose an administrative bad faith penalty on employers that violate the Texas payday law by failing to pay wages. There's not a corresponding increase in penalties for any claimant who might file a claim in bad faith. It's just on employers. So that's HB 2614. HB 3226, minimum wage for essential workers would be $15 per hour. HB 3307, minimum wage for state-supported living center direct care employees would be $15 per hour. So you see, there are a lot of minimum wage related bills going on here. In the area of regulatory enforcement and criminal penalties, HBs 166, 2285, 1655, 3520, and SB 315. I told you there were a lot. These all relate to restrictions on the age of persons employed by or allowed on the premises of a sexually oriented business. We'll see if one of these passes this time around. I wouldn't be surprised. HB 540, this would provide that a municipality or a county would not have the authority to require a labor peace agreement as a condition of engaging in, like a public contract with a municipality or a county. Interesting thing there. HB 1152, SB 1978, it basically expands the criminal penalties for unlawfully prohibiting an employee from voting to the early voting process. Not much of a surprise there. HB 1592, HB 2055, and SB 589, that would create what's called an interim registry for certain employees who have been accused of employee misconduct, and they're employed by a facility that provides care to individuals with an intellectual disability. Now, I wouldn't be surprised if this goes forward, that they also extend it to people who have limitations based on, age, or also minority capacity too, youth homes or something like that. I can see that also being applicable there, but the current bill just restricts it to intellectual disability. More bills under regulatory, HB 3454. Basically, it would prohibit employment and occupational licensing restrictions based on a person's prior conviction for nonviolent, non-sexual offenses. That would cover workers in various industries there relating to home service and delivery and commercial truck driving and so on. All right. HB 4290. This would prohibit covenants not to compete for lower wage employees, and basically anybody earning $15 per hour or less would not be subject to covenants not to compete. SB 424, first-time violators that are small businesses would have to be given a chance to remedy a violation prior to a penalty being imposed. Now, this would apply to all administrative agencies and administrative penalties. The important thing is for the TWC, this would impact some of the things that our agency does, and that might impact, for example, the bad faith failure to pay penalty under the Texas payday law. It might also impact some penalties for late wage reports or late unemployment tax payments under our unemployment tax laws. So keep an eye on that one for small businesses. That's definitely on the side of small business. Okay. And yeah, now graduating to unemployment insurance related bills, HB 7, extremely important, and its Senate counterpart, SB 1182, HB 7 has passed the House. It's in the Senate now. And this would exclude benefits ineffectively charged due to the pandemic from the computation of the replenishment ratio. And y'all, I cannot overemphasize how important this is for the unemployment tax rates this year. Y'all might have noticed that the TWC did not issue 2021 UI tax rate notices in the first week of December as we usually do. That's because of the pandemic and the extraordinary impact that the pandemic benefits have had on the State Unemployment Insurance Trust Fund. This bill, HB 7, fundamentally changes the way the state unemployment tax rate is calculated. You ought to take a look at that bill yourself and just see how important it is. But basically, it would keep the benefits that all the claims that have resulted in chargeback protection because of the disaster, or somebody leaving because of catching COVID, or they're under quarantine or something like that. All of those benefits would normally be recovered through the replenishment ratio and the replenishment tax. This bill would keep them from influencing the replenishment ratio. If this bill passes, it will be very, very important in allowing the TWC to finally calculate the unemployment taxes and let y'all know what they're going to be. More on that later. HB 145, that would remove the waiting period for unemployment benefits altogether. HB 157 and the Senate counterpart 2103 would increase the range of hours for shared work programs. Instead of the current 10 to 40%, it would be a reduction in hours from 10 to 60%. And this is good because shared work plans are really great. For anybody who has had experience with that, they're really useful. HB 1634, this would require 60 days advance notice of layoff or relocation of call center positions if at least 50% of the call volume is handled by the affected employees. Any violations of that notice requirement would result in loss of public subsidy for call center operations and also disbarment from future public contracts. And it would also require that call center services performed on behalf of the state agency must be performed in Texas, and that would affect, basically unemployment claim call centers too as well. Those are already performed by Texas employees. More on UI, and y'all, I have 8 total pages, 8 total slides on UI laws because there are so many. These bills, HB 1782 and 2128, would change the base period of the claim to make it more flexible and allow more people to qualify monetarily for unemployment benefits. Unemployment benefits continue. HB 1985, SB 469, those would waive the work search and waiting period requirements during the time of a declared disaster. HB 2014 and its counterparts would exempt from unemployment taxes and eligibility anybody who serves on the appraisal review board for an appraisal district. That has been a hotly contested item in the past several years. The Texas Supreme Court finally had to rule on it in the year 2017. The Supreme Court finally said, look, appraisal review board members, they are covered as employees under unemployment laws. They have to be treated as employees. So that's been the law. This would change that law. HB 2130, that would define as unsuitable a job at a workplace where the employer is not following health and safety guidelines, or where the risk of infection is just so great that it can't be mitigated under the circumstances. HB 2196, this would change the definition of disaster to exclude other public calamity requiring emergency action. It would also require a section of the labor code allowing the governor to suspend the waiting week requirement for claimants due to a declared disaster. Also would take away the authority of the governor to suspend statutes, but would leave the governor with the power to suspend agency rules. HB 2239 and HB 3501 would relieve employers of tax liability for periods during which their businesses are restricted by a disaster order. So basically, if their business is shut down because of a city, county, district, regional, or state or federal regulation, they would be relieved of tax liability and other types of taxes as well. The only thing is that this might create a compliance issue under the Federal Unemployment Tax Act, because by federal law, we collect the state unemployment tax. And if the state unemployment tax is not being collected, the Department of Labor might be concerned about that. We would just have to see. This will have to be approved by the Department of Labor before it can proceed in the legislative process. HB 2273 and 3704, that would add a new subsection to the urgent, necessary, and compelling statute, basically exempting from disqualification any claimant who has a work separation due to sexual harassment if they have reported it to the employer, to a law enforcement agency, to the TWC Civil Rights Division, or the EEOC. And the bills named at the bottom would basically forgive claimants from having to repay unemployment benefits if the agency paid them in error. More UI bills, HB 2408. This would change the computation of the weekly benefit amount. Currently, the weekly UI benefit amount is 1/25 of the high quarter wage amount in the base period. This would change it to 2/43. I love that math. This is going to be real good news for people who are highly skilled in math. The maximum weekly benefit amount would be 60% of the average weekly wage instead of only 50%, close to 50%, 47.6% under current law. And HB 3050 would create an interesting exception to the chargeback statute for a seasonal employer. If the employer's workforce is at least 75% seasonal during the most recent 3 calendar years, they would be eligible for chargeback protection if they get a UI claim from a seasonal worker. HB 3620, that would provide alternative base periods and also higher maximum benefit amounts during extended benefit periods. It would also require TWC to give notice to claimants of how they can enroll for health insurance. It would waive improper unemployment benefits under certain circumstances. It would also limit the application of the labor dispute provision and make it easier for people who are affected by strikes to qualify for unemployment benefits. There would also be a 30-day waiver of waiting week and work search requirements in a very niche situation if the number of unemployment claims has increased 5-fold during the preceding week. Suitable work would not include a workplace that is in violation of safety and health protocols. HB 3697, this would basically impact the eligibility for UI benefits of employees if they leave the work to care for a minor child, if they get COVID or something like that. HB 4221, this would temporarily waive unemployment benefit eligibility conditions, the work search requirement, and so on, and also waive recovery of improperly paid benefits. SB 16, this would prohibit the dissemination by a state agency of an individual's personal data. The implication here is this is something that we would have to run by the Department of Labor, because under current law, we give employers all the claimant information if they are going to be in an appeal hearing. And this would limit some of that because the claim documentation contains the claimant's personal data. SB 469, another waiver of eligibility conditions during a public health disaster. And finally, SB 1305, This would require TWC to annually notify employers in writing about the shared work program. SB 1726 would be real good news for a lot of performing artists and related occupations, restaurants and pubs. The tax rate would be frozen where it was on October 1st of last year and would exclude the replenishment tax. That's huge. The special rate would be good for close to 2 years. SB 2102 would remove the waiting period for unemployment claims completely, not just for disasters, but completely, just get rid of it totally. Okay, major federal bills. The American Rescue Plan Act, ARPA of 2021, that extends CARES Act unemployment benefits until September 4th of this year. That includes $300 federal pandemic unemployment compensation added to each claim that is payable. So if they qualify for even $1 of partial unemployment benefits, they'll get that $300. The $100 mixed earner unemployment compensation program will start soon with the same expiration date, and those benefits will be backdated to January. We've just been waiting for Department of Labor guidance. The PRO Act has passed the House. It's in the Senate now. It would make it much easier to get unions established at workplaces. It would also do away with right to work laws in 27 states, including Texas, that have them. So basically, somebody could be required to pay union dues. If there's a union there, they could be required to pay union dues. Even if they don't particularly want to, they'd still have to do it. Executive Order 14,002, January 22nd, 2 days after President Biden was sworn in, he instructed the Department of Labor to issue guidances to states regarding the situations under which employees might be able to quit a job or refuse work if they have a reasonable fear of COVID-19. So we are still waiting on official guidance from the Department of Labor on that. Now, I'm running out of time, and I want to make sure that we allow time for the video presentation from
Tommy, this is Pam. We are not going to show the video. We're just going to email the link to all our participants. So
okay,
you're in great
very
shape.
good.
Thank you.
All right, well, that's very helpful. Thank you, Pam. All right, so just basically on unemployment tax, some things are outside of your power to control, like whether there's a deficit tax or an interest tax, or what the replenishment tax turns out to be because of all the benefits that were paid out but not charged back to employer accounts. Employers can't really control that, but they can control the things on this slide. If you report wages and pay taxes on time, that means that those wages can be used to compute the tax rate, which definitely helps keep the benefit ratio lower. That helps with the ultimate effective tax rate. So report wages and pay taxes on time. That helps keep your tax rate low. Also, if you acquire a business, keep the potential cost of a transfer of compensation experience in mind. Take that into account when you're negotiating the purchase price of the business, because if the compensation experience transfers due to the acquisition and gives the business, the successor, a higher tax rate than they thought they would have, that's going to be an added cost that they might regret later. So be aware of the transfer of compensation experience. Keep in mind that if there is an acquisition and the entity that is being acquired, the predecessor, owes unemployment taxes to the TWC, that unemployment tax debt is going to pass along to the successor entity, even if there's not a transfer of compensation experience. So be aware, be an informed buyer if you buy a business. New unemployment tax rates, like I briefly mentioned earlier, usually we publish the tax rates, send out the tax rate notices, after the first week of December of every year, but 2020 was not an average year. We had, more than 1,000% extra unemployment claims paid out. We paid out over $40 billion in unemployment benefits, which severely depleted the state unemployment insurance trust fund. We had to get advances under Title 12 of the United States Code from the U.S. Department of Labor in order to pay unemployment benefits. That means there will be a deficit tax and an interest tax for 2021, but exactly what those rates will be, we still do not know. We are working with state leaders on legislative changes, and I mentioned HB 7 already, and that would affect the replenishment ratio calculation. Once we have all of those pieces in place, then this agency can compute the tax. Now, the good thing about HB 7, if it passes, that would help with the replenishment ratio. But it would also help with other components of the tax rate, like the replenishment tax and the deficit tax and the interest tax, because under the section 204.067 of the Labor Code, the commission has discretion to adjust those taxes based on economic conditions in the state. That will be very important in June when the TWC is finally setting the rates, and will publish the rates probably in very early July. And because of all these delays, the tax payment deadlines for UI taxes have been extended. First quarter taxes won't be due until August 2nd, 2021. Normally the deadline is April 30th, but this is a little bit over 3 months of extra time. The second quarter of the year taxes won't be due until September 30th. So that's good. That's a little bit of extra flexibility.
Hey, so Tommy, I see that your slide says 1254, but it's actually 1256. And I have already 4 questions that people want to ask you.
Okay, well, good deal. Let me just quickly say then, Lisa,
Thank you.
that the issue of fraud, and especially identity theft fraud, look on my presentation to see the 2-step process for following in those cases. And and that's basically it. So Lisa, let's have those questions.
Perfect timing. Thank you very much, Tommy. All right, I wrote them down. Excellent questions, y'all. And if you have some more, please know that in the PowerPoint you're going to get at the end of the session, Tommy does want to hear from you, right? And you've always been there. And I personally have asked you questions after a webinar. So I can vouch personally for your quick to response. All right, we have a first question. We are a Texas employer, but we have a facility in Tucson, Arizona. Would the OT apply to those employees since we are headquartered in Texas?
Okay, so we're talking about overtime hours?
Yes, overtime pay, I'd say. So we are a Texas employer, but have a facility. It came in when you were talking about overtime.
Okay, yes. Generally speaking, it doesn't matter where they work the hours as long as it's not in a foreign country. There's a general exception to the Fair Labor Standards Act for work and services performed in a foreign country. But as long as they were performed in the United States, those hours are going to be combined. So if they go over 40 for the 7-day work week, there's going to be an overtime pay calculation to do.
Okay, great, thank you. Question number 2, and there's a whole bunch actually of questions about this, and you and I and Pam and Kristen talked about it ahead of time. So I work for a physician practice, and we have received a large amount of fraudulent claims on our physicians, and somebody else said on our current employees. What can be done, and why is this such an issue? Really, someone said since the beginning of the year. What do you and then I'll keep going, hang on, I'm kind of combining 2. So what would you recommend beside filing a fraud report on the portal, do you have any idea how their confidential information is getting out there for people to file using their Social Security? Is there a plan to mask Social Security on mailed correspondence in the future? Thank you, Tommy.
Very good. Just real quickly on the Social Security number, my agency already disguises the Social Security number on a lot of the agency correspondence, not all of it, but y'all, I guarantee that that's not the main source of the identity theft. We've seen well over 300,000 identity theft claims just since the pandemic began, just in Texas, just our one state, over 300,000 identity theft
Wow.
claims. Our fraud unit is currently working on 117,000 pending identity theft fraud investigations or, reports. So it is a gigantic problem, and it's nationwide. Nationwide, well over $40 billion has been paid out just to fraudulent, criminals, people who file these claims like this. And so we're doing the best we can to keep up with it. What we do is we request a two-step process. Step number one, respond in a timely manner to the claim notice and document your timely response. Indicate on the back of the form that the employee is still working and that it's okay to, if you want to write in big bold letters, fraudulent claim, identity theft, go ahead and do that. That we see a lot of people doing that, but they will act quickly. And then the second step is to send just a brief email to our fraud detection unit, our fraud investigation department, the benefit payment control department. And it's at that email address that is on the second to last slide of my presentation, twc.fraud@twc.state.tx.us. And basically give the claimant's name and last four digits of their Social Security number and the employer's name and account number, and then a brief description of the problem, which is basically that this is a fraudulent claim. That person is still employed. They have told us they did not file the claim. This is identity theft. Please investigate. And what they'll do is, as soon as they confirm that, they'll lock the claim down and they'll flag it so that any attempted claim activity is routed immediately to the fraud investigators. So that's bad news for the fraudsters, but it helps control the payments. How this happens, y'all think back on all the reports you've seen in the media over the past several years about gigantic hacking incidents where large financial institutions, credit bureaus, banks, and other financial institutions, sometimes even governments, have been hacked. All of those hacked and stolen databases end up on the dark web, and criminal gangs buy those databases. And there is a huge profit motive, and this is cartel level activity. This is not just individual people. The bulk of it is by organized criminal elements, and it's a numbers game. They're hoping that a certain percentage of employers won't pay attention to these claim notices and that nobody will notice, and it'll give them enough time to siphon off some fraudulent benefits before it's stopped. So that's where most of this is coming from. It's all of these gigantic database hacks that you've read about in the recent years. So yeah,
thank you.
Hopefully that helps.
Yes, and we've captured a couple of website addresses that we're gonna include that in the email. We have the Texas WorkShare. So Tommy, as you made that statement of the Texas WorkShare program, there was a lot of conversation where other HR professionals have used that and endorsing it.
Oh, good.
So captured that connection, as well as Kristen gave us a publication about how to navigate that program, and then Pam gave us the fraud. So for those of you who aren't able to capture those websites in the chat, we're going to make sure that it's included in the email that you all are going to receive. So with that, those are the questions that I've had, and it was 1:05 now. So we want to be, timely for you, Tommy, as well as our participants. I want to thank you for being such a key advocate for Texas employers, as well as the HR professionals. As you know, we are responsible for really understanding the changes that are going on, and then being that HR, that organization HR superhero in organizations regarding this subject matter. So we thank you for your time. Also, participants, I just want to make sure that you know that you will be, that this event is approved for 1 hour of business credit from HRCI and SHRM, and that those of you who attended the entire session, you're going to receive a follow-up email from the Texas SHRM's office with the CEU information, a copy of the slides that has Tommy's information. He encourages you to contact him. And we know that this was a jam-packed session. You will also get Emily's video, and we've recorded this for you. And it's going to be available to be viewed for a certain amount of time. So we encourage you that when you get that email, if you want to listen to it, that you do that within the next week and make an action plan, right? Because it's not worth the time if you just listen and come to webinars, but you don't actually make an implementation plan. So, Tommy, any last words for our HR superheroes on the line that are saying goodbye?
Just be careful what you promise to employees, and keep your promises, and just do the right thing for the right reasons, and don't be shy about contacting our office if you have any questions. Thank you very much.
Great, thank you.
Thank you, Tommy.
And thank you all the participants. We appreciate you.